Check 1 2 1 2 1 2 3 4.
Recording in progress.
Thank you very much. We can start. Good morning, honorable members, and good morning to colleagues here and also those ones in the virtual platform, and good morning to our support staff. Firstly, let me take this opportunity to welcome everyone and declare this meeting officially opened. And let me convey the special welcome to all our stakeholders with us today and also the ones at the virtual platform. Then, according to the agenda, we'll quickly move to the apologies. Mercy.
Thank you, Chairperson. Good morning to you, Chair, to honorable members, the stakeholders and colleagues. I only have one apology, Chairperson, as indicated yesterday, Honorable CBC. Other apologies that may come through, Chair, I'll let you about them as they come, Chair. Thank you so much.
Thank you very much. I saw also in our group, there's also an apology of Honorable Cebekhulu and the outstanding apology of Honorable James Njonjo. I will then, just before,
for Honorable Notnagel as well, and I submitted it to Mascot.
thank you very much, Honorable Ntuli. And lastly, the apology of Honorable Notnagel. I will then request that Honorable Gondwe.
Chair, please note that Honorable Schreiber is running a bit late, but he will be joining us soon.
Okay, thank you very much. Firstly, I will request that we introduce ourselves, especially the honorable members, and all our colleagues will introduce as they present. My name is Teliswa Mkweba. That's my name, a member of this portfolio committee and the chairperson. I will then request that all honorable members introduce themselves. I will start with you, Honorable Maneli.
Morning, Chairperson and everybody. My name is Cindy Swamaneli, the member of the Portfolio Committee.
Morning, Chair. Greetings to everyone in the meeting. My name is Makoni Ntuli, the member of this Portfolio Committee.
Good morning, Honorable Chair, honorable members and colleagues. I'm Miriam Gibi, a member of this Portfolio Committee. Thank you.
Thank you very much, Chair. Good morning. Once more, Chairperson, colleagues, members of the staff, and our stakeholders. My name is Rosina Komani, the member of this Portfolio Committee. Thanks.
Good morning to everyone in attendance. My name is Dr. Mimi Gondwe. I'm a member of this committee. Thank you.
No, thank you very much, honorable members. As you are aware that the committee advertised to receive the return submissions relating to the Public Service Amendment Bill and the Public Administration Amendment Bill in July 2023. We have received the return submissions from colleagues, and now we've invited all the stakeholders, and furthermore we have invited the Office of the Auditor General to provide inputs on the two bills as well. And honorable members, in attending to these bills, as legislators were aiming at professionalizing the public service, and at the center of a capable development state, it is a professional public service that is run by competent and highly skilled and incorruptible civil servants. Your return submissions are highly appreciated as they will assist the committee in sharpening the public service. The purpose of today's meeting is to afford our stakeholders an opportunity to provide oral submissions on the bills. And honorable members, if we remember, we had a meeting in September 2023 on the analysis of the written submissions by our committee support staff. And so we are still in the public participation process. And I would like to urge all members to pay attention to the submissions. And where there is a need for clarity of a particular point, I will then, honorable members, give you that opportunity. And now we are starting with this process, and of which now I will then hand over to the South African Local Governing Bargaining Council. Thank you very much, honorable members.
Thank you very much, Chairperson, Honorable Chair of the Portfolio Committee, and my greetings to your good self and to the members. My name is Busi Hlumbane. I'm a councillor. I'm also representing SALGA, being a chairperson of the South African Local Government Bargaining Council. Maybe, Chair, to share with your good self and also to clarify who this bargaining council are. We are the party that consists of 3 parties, which is SALGA, the employer organization that represent all the municipality throughout the country, as well as 2 recognized trade unions, which is IMATU and SAMU. The 2 unions are about 98% of the employees employed by in the local government. We are therefore the main representative body of a local government as far as the interest of the municipality and their employees are concerned. We also have a number of senior leaders in SALGA in attendance today, as well as 2 presidents of recognized trade union, IMATU and SAMU. We also have our attorneys from ENS who will be making our representation. As a bargaining council, we thank you, Chairperson, for the opportunity to address you in our concern regarding the Public Administration Amendment Bill. We are here today to express our deep concern with the provision of the bill, and we have chosen to appear in person as a group to show that all 3 parties are unified in our opposition to Section 17A and 17B of the bill. We are extremely concerned that the bill will have a negative effect of the collective bargaining arrangement and relationship between the bargaining council parties, which have taken years of hard work to achieve. We are also very concerned that what is being proposed in the bill may lead to a breakdown in the labor relation in the sector and an increase of industrial action, which will not be good for our sector. It is also quite worrying to us that our views so far have not been taken very seriously by DPSA. A number of letters have been written to DPSA asking for more consultation, and they have not yet responded to. Chairperson, we request that you receive our representation today with an open mind, and that you will give due consideration to what we have to say as a matter of an extreme importance to us. We have submitted a written representation, and our attorney from ENS will take you through those representation. Chairperson, allow me for a second to introduce the members that are here. As I have indicated earlier on, that we are represented with 2 trade union and the representation from SALGA. Allow me, Chair, when I call the name, a person will just raise a hand so that you'll know who's representing who. In SALGA representation, we've got Mr. Zwendlala, who's also representing SALGA. If he can just wave a hand so that the member of committees can be able to see him. And we are also having a Johan Greveling from Salga. From Imatu, we've got Craig Adams, Mr. Craig Adams. And we've got the president of Imatu, Mr. Keith Swanepoel. We've got a president of SAMU, Mr. Mukoto, in our midst. We also have a general secretary, Mr. Tumisani Makakula. Thank you so very much. Mr. Bill Govendai is our secretary in the office of the Bargaining Council. Chairperson, thank you very much for this opportunity. Once more, Chairperson, allow me to introduce Mr. Ivan Lawrence, who will be taking us through the presentation today. Mr. Ivan. Thank you so much, Chair.
Thank you. Good morning, Chair. Good morning, Secretary. Good morning, members of the Portfolio Committee, representatives of the South African Local Government Bargaining Council, SALGA, and also SAMU and Imatu. Thank you. We've done a PowerPoint presentation. I'll try and keep as close to the time limits as possible so that we do conclude it within those parameters. So before I actually begin the address, let me just sketch the context. There is a Public Administration Management Act already in existence. It was established in 2014. And if you look at the preamble, that clearly sets out what the objective of that legislation is. It's to promote basic values and principles governing public administration. And it goes back to Section 195 of the Constitution, where what clearly is indicated as far as public administration is concerned is the need to provide for the transfer and secondment of employees in the public service, to provide the minister with the power to establish minimum norms and standards for public administration, and also to establish the Office of the Standards and Compliance, where these minimum norms and standards can then be regulated. SALGA has raised a number of concerns with the amendments to the Public Administration Management Act. I'm going to refer to it as PAMA. But before dealing with those concerns, perhaps it's useful for me, without repeating what's already been said, to give you some contextual background as to exactly what the South African Local Government Bargaining Council is. It's a bargaining council. It's established in terms of the Labour Relations Act. The parties to that council are the unions, SAMU, and Imatu on the one part, and then you've got the South African Local Government Association, which is the employer organization representing some 257 municipalities across the country. What's interesting about SALGA in particular is that it's established in terms of the Organized Local Government Act as a national organization. Section 21A establishes it. So unlike other employers' organizations in the private sector, this is something that's statutorily established as the body that will carry the mandating functions for the employers, which are the municipalities in that particular sector. The parties to SALGA meet at intervals, normally on a yearly basis, sometimes on a longer basis, where, like in every other industry where there's a bargaining council, they sit down with organized labor and the employers' organization, and they conclude collective agreements about wage increases and conditions of service. And that essentially is the background against which this whole entity exists. Now, the Public Administration Management Amendment Bill was first published for public comment on the 6th of April 2021. The SALGBC submitted its comments to the DPSA to the effect that if the bill was enacted, aspects of it would severely impact and erode collective bargaining. Now, you will know that collective bargaining, particularly in the municipal sector, collective bargaining is something that is a right that's entrenched in the Bill of Rights in the Constitution. That is further endorsed in the Labour Relations Act. And there was a concern that by enacting particularly 17A and 17B of this bill, amendment bill, you're going to erode some fundamental rights that had already been entrenched. During the consultation process, You know, the SLGBC made it clear that they don't support particularly 17A and 17B, but in spite of this, you know, the DPSA proceeded to advise the Portfolio Committee that there was general buy-in from of the bill by the affected parties. Now, what we want to deal with, and to cut to the thrust of this, is which aspects of the bill does the SLGBC and its stakeholders have issue with. So there are a number. It's not just 17A and 17B, but principally 17A and 17B are where the main concern lies. SAMWU, on the one part, has some concerns about Section 62C, which deals with the secondment in the Public Administration Act. Now, secondment already exists as a prospect in the 2014 Act. What the amendment has done in Section 2C is say that people can be seconded without their consent, provided this is operationally justified. Now, the concern that has been raised with that is that there is no description in the bill as to what constitutes operationally justified. That's not defined. And that essentially is SAMWU's concern about that aspect of it. The other aspect that SAMWU has some concern with is the new Section 8.4 that's been inserted by Palmer. And the objectionable part is the part which states that the Minister of Public Service and Administration may prescribe that certain transactions between an organ and state and employees which are remunerated but not for profit do not constitute conducting business with the state. Now, Section 8 makes it an offense and prohibits, you know, individuals who are being in the employ of the state or receiving remuneration to conduct business with the state. The concern with this caveat, as we can call it, is that it also is not described those circumstances under which the minister may exclude certain of these activities hasn't been particularized. You know, that essentially deals with SAMWU's concerns. Then the concerns which may lie at the thrust of our address today are with 17A and 17B, which have been inserted. 17A deals with the removal of unjustifiable disparities in relation to remuneration and conditions of service across the public administration. And that is worded as follows, that it's subject to applicable legislation, any collective agreement, legislation governing employees in public administration, and the Minister of Public Service and Administration may prescribe, you know, measures to remove these disparities after consultation with the COGTA Minister, the public, and then, once that happens, norms and standards can be then established to set upper limits of remuneration and conditions of service outside of the bargaining council. Now, that particular provision outside of the bargaining council was inserted after representations had been made by the SLGBC, because previously it cut across all levels, you know, people within and outside of the bargaining council. We can't take that issue any further because it doesn't fall within our remit and mandate. You know, it now affects people outside of the bargaining council. Then the next part is 17AB. That's to remove unjustifiable disparities in the public administration among employees, provided this does not reduce salaries. Now, the SLGBC made representations that it was not too unhappy about this, but it should not just be limited to reducing salaries, but also conditions of service. The DPSA, you know, hasn't taken that up. They have not extended this to deal with conditions of service, and that then continues to be a concern for the SLGBC. Section 17B, you know, that is a new insertion, and it basically reads as follows. Subject to the Labour Relations Act, the laws governing employment of employees and any collective agreement, no employer in the public administration may enter into a collective agreement in respect of conditions of service with financial implications to determine them for employees without a mandate from the Committee of Ministers. The Committee of Ministers must then determine the mandate, take into account affordability and other factors prescribed by the Minister in consultation with the Minister of Finance. And conditions of service is then described to include a whole host of things: annual salary adjustments, salary scales, levels, performance bonuses, pension, benefits, and other benefits. The Committee of Ministers is described in the new amendment as consisting of ministers responsible for finance, local government, education, public service and administration, and other ministers of cabinet may also be designated into this committee. The committee then establishes an intergovernmental forum in terms of Section 9 of that particular act, which includes premiers and deputy ministers, organized local government, and other members of the committee, who then can consult for this particular purpose. That, in essence, is the makeup of the new provision. As regards Section 17A1, it provides that the minister may now prescribe norms and standards subject to applicable legislation. And as I said, that excludes 17A1A from the particular remit of the bargaining council. 17(1)B, as I said, that still deals with, it doesn't deal with conditions of service, and there's a risk that that now may result in the minister interfering with existing conditions of service of employees. The concern that's been made is, it begs the question as to why we need to do this. There's an Employment Equity Act, which basically provides for any disparities or unjustifiable issues to be dealt with. There's a code of good practice that's been enacted under the Employment Equity Act. The Employment Equity Act can deal with income differentials. Also, if one looks at the existing legislation, you can actually look at, for example, the current Public Administration Management Act. That already contains provisions where norms and standards in terms of Section 16 can be set. The Organized Local Government Act, basically that exists as well. The Local Government Municipal Systems Act already contains provisions that give the minister, COGTA minister, the power to establish regulations and guidelines in terms of which standard setting, norms and conditions can be established. So the concern is, why tamper with this? By introducing a new piece of legislation, you're going to now put into the picture a legislation that likely will stand in conflict with existing legislative measures. And you create that tension, and that then results in litigation, we know. Whereas if you use the existing process where you use delegated legislation like regulations and guidelines, that's easier. It permits you then, to use that regulatory function to establish norms and guidelines. Now, just turning to Section 17B. Just to recap, we know that, as I said, collective bargaining is a right that's established in terms of Section 23 of the Bill of Rights in the Constitution, and that right is accorded to the players in the private sector and in the municipal sector. If you're going to be limiting those rights, then we say that limitation must be in terms of Section 36. Additionally, municipalities are, in terms of the Constitution, respected as autonomous and autonomous executively and legislatively. Apart from the bargaining practices, procedural collective agreements are already in place, and these are supported by several statutory provisions that are currently working. And they, first of all, regulate the establishment and maintenance of norms and standards. They deal with benefits and remuneration and disparities and their removal. They regulate the collective bargaining process. The mandating process of SALGA, for example, is clearly set out in various pieces of legislation. Before SALGA can actually go out and negotiate with organized labor, it has to, in fact, get a mandate from the various municipalities. That mandating process is safeguarded in the sense of ensuring that what they do is they make sure that there's affordability, they make sure that, you know, the municipalities are in a proper position to make that offer when they make that offer. Effectively, with this new Section 17B, it really removes that negotiating power or that collective bargaining right from SALGA, almost rendering SALGA redundant, and puts this now into the hands of the Committee of Ministers. So I just want to deal for a minute on the real rub, which is Section 17B. You know, the mandating arrangements, according to the DPSA, that have been inserted now are not going to be eroded, but what they say is they're rather there to ensure that collective agreements are capable of proper interpretation. The amendment that they propose reads as follows. Subject to the Labour Relations Act, the laws governing employment of employees and any collective agreement, no employer in the public administration may enter into a collective agreement in respect of conditions of service with financial implications or determine them for employers without a mandate from the Committee of Members. SALGA will then effectively, in the negotiating process, have to revert back to the Committee of Ministers if Labour rejects the employer's mandate and offer. The constitutional right of municipal employees and employers to negotiate and determine their terms and conditions of employment of a sectorial collective bargaining process is then clearly undermined by this particular process. You know, if you look, for example, at the Municipal Systems Act, Section 71, I believe it is, SALGA must first, before it even goes out to negotiate, it must first consult with the Financial and Fiscal Commission. That Financial and Fiscal Commission is set up in terms of Section 220 of the Constitution. Not of subordinate legislation. The actual Constitution sets it up. And it consists of an independent body of experts who look at various factors in determining affordability and determining feasibility of any offer that's going to be made. Then you've got to look at Section 5 of the Organised Local Government Act supports this whole functioning of the Financial and Fiscal Commission. Section 71 of the Municipal Systems Act goes on and says that budgets of municipalities and fiscal capacity and national economic policy have to be taken into account by SALGA in consultation with these bodies like the Financial and Fiscal Commission before they actually prepare an offer or consider making a proposal that they would take to the collective bargaining table. Section 72, which I alluded to a few minutes ago, you know, that gives the minister the right to pass regulations and guidelines after consulting with the bargaining council, and that would be the SLGBC, the minister that's proposing this legislation of public service and administration, to set standards that deal with, amongst other things, remuneration, that set standards that deal with things like even the secondment of employees, transfers of employees, the regulation of remuneration and conditions of service. There's also a clear direction, imperatively stated in Section 72, that the minister, when issuing regulations and guidelines, must take into account the capacities of municipalities to comply. It can differentiate between different municipalities and determine different dates for the implementation based on affordability. So as you can see, I mean, even more than that, you've got Section 66 and 67 of the Local Government Act, which basically says, Section 66 deals with staff matters. And it basically says that within a municipal manager must, within a policy framework, determine and develop a staff establishment for that municipality. And in that process, they've got to look at attaching remuneration and conditions of service that would apply to specific posts. They've got to then look at human resource development, which basically deals with the municipality then dealing with recruitment and selection, dealing with the development of service conditions, and the promotion and demotion of staff and remuneration measures. You've also got, the ILO, which basically, Article 4 of the Right to Organize Collective Bargaining Conventions, number 98, states that measures appropriate to national conditions shall be taken where necessary to encourage and promote the full development and utilization of machinery for voluntary negotiation between employers and employees. This does envisage the possibility of going back when you're negotiating to your principles and asking for a mandate in this particular type of situation, analogous situation. But the limitation there is that you may not reject the mandate on any other grounds except and interfere with the autonomy of parties to engage in that negotiation unless there's procedural flaws with that particular proposal. So, in essence, what Section 17B does is it accords this Committee of Ministers full discretion to reject a collective agreement in the event that it was entered into without a mandate for the Committee of Members. It renders literally that whole process a farce. It's quite clear that the power to negotiate does not sit in the hands of SALGA. SALGA, in terms of Section 60, first of all, it's a body that's established by law. There's original legislation that establishes it. There's original legislation that sets out what its functions are. The Municipal Systems Act at Section 71 says, under the heading Bargaining Council Agreements, that organized local government, that's SALGA, must before embarking upon any negotiations consult, as I said, with various bodies. Financial and Fiscal Commission must consult with the Minister, must consult with any other party that may be prescribed. They've got to look at budgets, they've got to look at fiscal capacity, they've got to look at national economic policy. And if that's not enough, what you've got is the ability of a minister that is directly involved and responsible for this portfolio, local government, being given the power to establish regulations and guidelines. If you're concerned about norms and standards, then utilize that particular modality to correct things. The interesting thing is that in this particular sector, things have worked well. Even the DPSA has had to concede that they don't see anything wrong, essentially, with the mandating process, with the negotiation process that happens. This is a sector where you haven't had a strike in a number of years. I think it's more than 8-9 years. They've kept themselves to within the limits of what their mandate is, and I think the mandate is between 25% and 40%. Am I right, Craig? And they've maintained any of their wage and conditions of service agreements within that mandate. So it begs the question as to why do you want to fix what's not broken? It's working well. It's over the years withstood constitutional scrutiny. And what you have before you today is a collective front. You've got organized labor and the unions that sit in this particular industry all saying this is not a good thing. This is something that's going to undermine a fundamental right. And as I said, it's a bizarre thing to put up two pieces of legislation that are going to compete with each other. Which one are you now going to use? Are you going to now use this new Section 17B, or are you going to use the existing measures that are set out in the Municipal Systems Act and the Organised Local Government Act, in terms of which SALGA currently functions to obtain its mandating process. And then are we going to then be flooding the Constitutional Court again with litigation about competing pieces of legislation and the constitutional confusion that's going to result from all of this? People, you know, our position is that it doesn't make sense. Yes, there are 4 objections. Section 6, Section 8, you know, those are not principally our main concerns here today. Our main concerns are about interfering at the level where you don't need to interfere, where you've got legislation that manages this process, particularly 17B, which, you know, according to the South African Local Government Bargaining Council, is the most egregious and offensive part of this legislation. And the DPSA has not wanted to accept representations. So we're constrained to come here today and say, let's not do this. Let's not, you know, deal with messing up something that actually has worked well. You know, unlike in the public service. In the public service, we've seen, I mean, and we're not saying that the DPSA is not entitled to go and fix things in the public service. You know, outside of the municipal and local government sector. You know, that may be necessary there. But in this particular sector, it's autonomous. We understand that there may be a wish to have public administration seen as one generic entity, but you've got to respect what the Constitution does. The Constitution respects and acknowledges that there are different arms of government. You've got national government, provincial government, and local government. You know, at the end of the day, those municipalities, they create the income that pays their wages and pays their salaries and establishes their conditions of service. They're best placed to determine these on their own. You can't make this a one-fit-all-size shoe. You know, at the end of the day, even this whole process of removing unjustifiable disparities, you're giving that power to the Minister of Public Administration to deal with. The negotiating process for those that are involved in negotiations sometimes involves trade-offs. You know, what may look like a disparity looking from the outside in may not necessarily be a disparity. It may be a consequence of negotiations, trade-offs that Labour agree to at that particular level when they're negotiating. Now you're going to go and jump into that particular fray that you were never involved in and displace agreements and trade-offs that were reached over years of bargaining. Thank you. That's our submissions. Can I just check with my constituents that they're happy that I haven't left anything out? Thank you. Thank you, Chair.
No, thank you very much. From South African Local Bargaining Council, that in your presentation you have said you are also representing IMATU, SAMO and SALGA. Now, honorable members, this is the end of the presentation from SALGPC. I will then, I understand we won't take questions, but I will take hands that need clarities from the presentation. I'm taking hands, honorable members, if you want to raise your comments, clarities from yourselves, from this presentation. Okay, there's a hand of Honorable Ntuli.
Thank you, Chair, and greetings to the meeting once again. Baba, Chair, for me it's not a question seeking clarity, but one wanted to thank the Bargaining Council to take interest in the work of government and this portfolio committee regarding the bills before Parliament. As you've alluded to, Chairperson, that for us as the portfolio committee, there is not much that we can do with the presentation, except for asking for clarities, if there are any. But having no clarity-seeking question per se, but one thought we must comment the presentation and the submission, and also taking interest and also taking their time to come to Parliament. Thank you so much, Chairperson.
No, thank you very much, Honorable Ntuli. To the presentation, I think we have noted all your views and especially your concerns. And while I was noting, I have picked up, you've got more issues on the section 17B, and of which there is a support staff from Parliament, from the legal side of Parliament, and also the DPSA, and obvious in the next process, the department will come and present before this portfolio committee on what will be presented here today in your submissions. And we have noted, as well as honorable members, as we deliberate after this process, we will then be able to express ourselves on your issues and your concerns, and where you feel discomfort in terms of the intersections in the bills. But however, definitely thank you very much to yourselves. And we then move to the next presentation, COSATU. If you want to listen to other presentations, you can still remain, but if you've got other commitments, you can leave and join on virtual. There's also a virtual platform where you can also, listen to other presentation from today and tomorrow.
Okay, good morning, Chair and members, colleagues. Thanks for giving us space as COSATU to try to make our own contribution. Hopefully we can add some value as well to this issue. It's a bit of a juggling act, I think, as the colleagues from SALGA have also alluded to. I think it's about finding the right balance, trying to find what is a fair approach to it. But look, I think for us, we have quite a few vested interests in it, because obviously we have members who work in the public service, who work in entities, who work in local government, and of course workers are also across the country, the customers of the state at different levels. So look, Chair, we had kind of engaged on this bill quite significantly, both this bill and the PSA bill, which we'll be discussing tomorrow at NEDLAC, with the colleagues from government. I think in the beginning we had quite a few very strong concerns, objections to parts of the bill. I think in many fronts we were able to resolve many of the issues, not all of them, but I think in many instances we were able to resolve quite significant issues. And basically we were informed by the issue of needing to defend workers' hard-won constitutional labor rights, But I think at the same time, Chair, we also are, supportive of government's effort to deal with the issues of state capture, of corruption at whatever level, and also how to really build a capacitated developmental state, because we can see the state on many fronts is really struggling at all levels to provide or fulfill its mandates. Chair, I think as the colleagues from SALGA had indicated, for the bargaining council rather, we are still concerned about the clause 17B and I think C as well. We do think it's currently, as way it's drafted, it's a significant constitutional legislative overreach by national government in terms of requiring that national government, whether it's a committee of ministers or the Minister for Finance or whatever it is, that municipal and entity collective agreements will be subject to their approval. Chair, we think this can and must be rectified. We think it's fairly simple to rectify it if we want to ensure the bill is constitutionally compliant. Chair, we do fear, and without being alarmist or engaging in fear-mongering, we do fear that otherwise, if we don't fix it, it really could plunge local government, but also entities like ESCOM and Transnet, etc., really key institutions into a crisis. Constitutionally, we think it also undermines collective bargaining. And I think, Chair, it's not an idle thing, and no one wants to see labour market instability. But if you look at the current scenario in Tshwane municipality, for example, you can see the consequence of not managing collective bargaining properly. It can get out of control, and then it's very difficult for any party to pick up the pieces, to fix it, etc. So, Chair, on the Palmer bill, some of the clauses, we had a lot of discussions around the issue of transfer of employees. We were very concerned in the initial draft of the bill that it removed the need for consent for the transfer of employees, and we felt that is really open to abuse. It would have huge consequences for workers, for families, etc. So we were pleased that, Chair, through engagements, we were able to remove the issue of non-consensual transfers. That transfers should be there should be consent to it, etc. And so, Chair, we think if handled correctly, it can help to boost morale, support family stability, workplace productivity, etc. Of course, Chair, if it's handled badly, it can do the opposite, and it can really create unnecessary litigation and so forth. But we're pleased that on that front, we're able to remove the issue of transferring employees without the consent. And of course, I think we do welcome provisions that would specify that there's no cause in the break of service or result in the conditions of service being negatively affected unless the employee agreed to that in writing. And so this is a major issue for us, so we're pleased we had managed to resolve it. And I think we've managed to find in this issue of transfer employees some fair, rational provision at the end. On the issue of doing business with the state, look, I think, Chair, we all need to lead by example. We complain as COSATU, as affiliates, about politicians doing business with the state. We complain about people in the private sector engaging in state capture. So we think, Chair, it has to be a single set of rules that no one who receives a salary from the state, be it an office bearer, be it a public servant, should be doing business with the state. So we do support the provision which deal with that. We think these are critical for really to deal with the issue of the state being cleansed of the cancers of corruption, of state capture, which we really have seen are endemic throughout the state, from the public service to entities like ESCOM, Transnet, local government, etc. As to all of our benefit. And of course, the public at large really depends upon a state which is geared towards supporting the needs of the poor and the working class, and should not be a factory of entrepreneurship from whoever is in charge. So, Chair, in terms of again, there is some useful provisions here which speak to a bit of a cooling off period about trying to prevent this culture of people throwing javelins in the state, where senior management would create entities which invest in lucrative, dubious business adventures. And once that's been approved by themselves, they then just simply choose to resign from the state and they go and collect those rewards outside. And I think you would have seen recently, without mentioning the company, similar challenge at the Unemployment Insurance Fund, where people really have chosen to treat the state as a slush fund for themselves, and afterwards they resign and just simply go and join that better pay. Again, Chair, on the issue of agencies and entities, you've seen it time and again, senior officials in the state create these entities and agencies because they'll be outside the public service payroll where there's a cap on what management earns, and you go outside and you can earn double what you would have earned as a DG, for example. Chair, for quite a few years we've been raising, because often when we go to Parliament to make opposition submissions around the budget, how to manage the budget, etc., in a win-win way, people often say, well, the public sector wage bill is out of control. I think for us it hasn't been out of control. It's been stable at 35% of the budget since 2009. but we have seen disparities which are often unjustified arising in the public sector. So on the one hand, you have nurses and teachers, police officers, municipal workers, transit employees, etc., working under very difficult conditions. Then you have senior managers in the public service and entities, especially municipalities, often getting paid exorbitant salaries. So to give you one, silly example, you have a couple entities which manage traffic tickets. One of them is the Road Traffic Management Corporation. So the management team there, not even the CEO, the management team, gets paid more than the president of the country. And that can't be right. So instead, you find a perverse scenario where Treasury then says, well, the wage bill is out of control, impose a 0% wage increase, but there's no action for the real culprits, which should be the senior management. And it doesn't make sense, Chair. We should be having a single kind of a fair approach to it. So that's how we took the spirit of the issue of removing the unjustified disparities, not to harm low-income earners, but really to deal with the bloatedness on the top. Chair, our areas of concern, and I think it's similar to the colleagues in the SALGA Bargaining Council. So on the issue of the clauses 17B and C, or on the issue of collective bargaining and ministerial coordination. So there's basically two aspects to it. So the part which deals with the public service, where the committee of ministers should give a mandate for the government's negotiating team when they engage in collective bargaining in public service, we were fine with those provisions. As I think it's something that Kosato raised before, when you had a situation in 2020 where a very perverse scenario where you had a previous Minister of Public Service signing an agreement and that being disowned later by Treasury and by Cabinet. And that created the 2020 public service wage fiasco, where government said they don't know about this wage agreement, they went to court and they washed their hands of it. So we're very keen to avoid that kind of a repeat, because that really has poisoned the waters of collective bargaining in the state and even beyond that. So, Chair, so we'll find that, obviously that has had a cascading effect where 2020 there's no wage increase, etc. So we take a view that negotiations can only take place and be successful if all parties are mandated on the positions and the final agreements. So for the public service, we're fine. It makes sense that Minister of Finance, Minister of DPSA, etc., should be part of that team. Cabinet should approve it. There's no problem with that one. I think our area of concern, Chair, is what we think is legislative overreach, or creating a single public service through the back door, because you don't have a single public legislative framework. So we're concerned, Chair, that Clause 17B extends the mandate of the Committee of Ministers to collective agreements to entities. That includes the Transnet and ESCOM, etc., other SOEs, and to municipalities. So, Chair, for us, it's a little bit of a strange scenario, because these are separate institutions of government. They've got separate laws, separate acts, separate funding models, etc. But I think, in essence, Chair, Treasury doesn't contribute to state-owned enterprises to the salary bill. They don't contribute to local government salaries. They're not a party to collective agreements in SOEs or entities or municipalities, neither by practice or by law. In essence, Chair, the Treasury is not the employer in local government. So what is its status to go and approve a salary increase for local government? So we think, Chair, this is a really significant overstretch and without sound legal foundation. Chair, it also, just to take colleagues or members a step back, I think in the past, two out of the past 3 years, Treasury wrote to SALGA Bargaining Council to ask them to abandon a signed wage agreement in local government. They did similarly in Transnet and ESCOM as well. And that would have really been a recipe for collective bargaining, for labour market instability. Chair, we feel that, as the SALGA Bargaining Council colleagues have said, that this would in essence collapse collective bargaining in entities and municipalities. Why would you bother to negotiate with management there if it's subject to Treasury approval? You might as well then just simply go to Treasury and engage with them. We think this would be likely to be challenged. We could imagine, for example, an opposition-run municipality questioning how is the Treasury is approving their collective agreements. So, Chair, look, we do understand the principles of ensuring negotiators have a mandate, including government. There's no qualms with that. We appreciate negotiators taking into account the issue of affordability. Again, there's nothing offensive about that. But I think, Chair, equally we need to get the right balance and to take into account the separation of the spheres of government. There are overlaps, etc., but in essence, local government is a separate sphere of government. Yes, Treasury might say, okay, look, we do contribute to local government, but they contribute via conditional grants for water infrastructure, for housing, etc. If you don't spend that money as a municipality, you must return it to the state. You can't then go and take that money for electrification and use it to pay salaries. So you would have, for example, Chair Madibeng Municipality in Northwest returning money for infrastructure because they couldn't implement it. They can't then shift it like a public service department might be able to do within reasons. Chair, again, I fear, the China example is to really avoid undermining collective bargaining and labour market instability. And we do fear that we're heading towards that route. So we have maybe 3 options to consider, and this food for thought. We have engaged with our colleagues in DPSA and SALGA and so forth. One, Chair, a very simple, neat and clean one, is to take 17B1 and where it, so it speaks to that, any collective agreement in the public service, the employer must have had a mandate from the Committee of Ministers. The simple one there, Chair, is just simply to take the definition of public administration, which includes public service entities and municipalities, and just to delete administration and replace it with public service. So you speak to the public service institutions. That for us is a very neat and clean one, and we'll resolve it in one fell swoop, we believe. A second option, Chair, if colleagues in government are adamant there must be some sort of guidelines for entities and municipalities to take the same clause, so 17(1)(a), and where it has maybe inserted a new clause, a subclause A or a new clause 2, and where in the 17B1 where it said the employee in the public service must get a mandate from the Committee of Ministers, simply to tweak that in this instance, have a separate one for the employee and entities or local government, that when they're entering into a collective agreement in respect of conditions of service or financial implications, etc., that they need to consider inputs from the ministers, whether it's the Committee of Ministers, whether it's a Minister of Finance or Minister of Local Government and the entity. I think that's administrative, but don't make it obligatory, rather make it they're required to consider inputs. So they must listen, they must hear the views, and I think the SALGA colleagues already indicated that they do so already by law under the FFC, they do so with the Minister of COGTA, etc. And I think that's a fair one. I don't think that's one that, because an employer would simply be able to dismiss it. They'd have to consider it, and they'd have to, take that into account, and you could hold them accountable. Did they consider it, etc. But it wouldn't be that you're now subordinating them to a national minister, for example. I think, Chair, look, our principles maybe on this one are 3, and we really want to see how can we find each other. We don't want to see this never-ending cycle where we must take each other to court. And literally, Chair, it can be a matter of a few sentences how to resolve it, etc., to avoid that scenario. I think the one principle is that, requiring employees and entities and local governments to consult with national government before and or during collective bargaining negotiations have an impact upon the fiscus, so that's fine. We don't think that's an unfair principle, and I think the colleagues in SALGA Bargaining Council have already said they do that. You could see maybe how to enhance it or tweak it slightly. So that one is already there. I think requiring employers in the entities and local government to take into account affordability and other criteria set by the Minister for Finance during collective bargaining engagements. I think, Chair, they've already indicated they do that, but of course one can make it a bit tighter, more clear, etc. I don't think, anybody would object to the issue of affordability. Chair, you could consider a hybrid approach if a municipality's or entity's financial status does have a significant impact upon the fiscus. Maybe you distinguish in that regard. Maybe perhaps a better example is an SABC, or the post office, which is in serious crisis. You could have a more nuanced surgical approach in that regard, but we don't think it's correct to say for an entire sphere of government, it will now be subordinated to national government. We don't think that will pass a constitutional challenge. So, Chair, I think, in conclusion, we have made progress in our engagements. We do welcome many of the provisions in the bill, including those dealing with the issue of transfers, doing business with the state, the unjustified disparities. But, as indicated, we are concerned about extending the mandate and approval of the ministers to entities and local government. We are convinced that this is serious legislative overreach. We do really fear it will undermine and collapse collective bargaining in the entities and municipalities, and this we think is going to spark labour market stability. And often, Chair, I think the useful point about SALGA Bargaining Council input is that often in Parliament or in the public discourse, people say that there's too many strikes, it's out of control. But I think the colleagues in SALGA have said the last strike was about 8 years ago. It's not often workers go on strike, and really the workers go on strike as a point of last resort, and largely because collective bargaining has collapsed, as you've seen, for example, in Tshwane or other locations. So, Chair, we do hope that the Portfolio Committee and the DPSA will take into account our proposals to either limit the mandate of the committee ministers to collective bargaining engagements strictly in the public service, or to look at additional sub-clauses catering for collective bargaining engagements in entities in local government, indicating that they should consult or take into consideration inputs from the ministers responsible for Treasury, COGTA, the entity, and maybe have a two-pronged or more nuanced approach. But, Chair, I think in conclusion, it's critical that this is addressed in a manner that helps to resolve the concerns of government in terms of affordability and the relevant criteria on one hand, but also doesn't engage in legislative overreach, undermine different spheres of government, or collective bargaining, or create labour market instability on the other hand. We're hoping that our proposals, our thoughts can help resolve it, but really want to see how can we resolve it just to avoid legal challenges and avoid labour market instability. Because we do want to see government functioning well, but also we need to protect workers' rights and labour market stability. So that's our presentation in a nutshell, Chair, and hope we stuck to the time frame. Thanks, Chair.
No, thank you very much, Kosato, with your presentation. Honourable members, I'm taking hands for comments. Honourable Ntuli.
Thank you, Chairperson. And well, once again, Chair, one will sound like a record in thanking the presentation from Kosato that says to this portfolio committee the work that we are doing it is not in silos. We thank them for taking interest and taking their time for coming here, and also presenting their concerns, of which when the time comes, we'll be able to deliberate on. But again, I'm mentioning crucial notes of it in terms of the signage of the bills and the constitution, and vis-a-vis the people on the ground, particularly the working force. With those few words, Chairperson and the meeting, thank you very much, Kosato, for the presentation. We really commend it from our side.
Thank you very much, Honourable Ntuli, and thank you to the Kosato presentation. Like the first presentation, I can see the same section. You still have issues, but however, I think you also welcome some of the provisions in the bill, and also, in your presentation, I've noted that your concern is in the mandate, of the extending mandate of having what we call the Committee of Cabinet, and you have said even the South African Local Government Bargaining Council, it undermines your responsibilities, and I think as honourable members, we are also noting all these concerns, but however, you don't have issues with some of the insertions to these bills, but you want us to make sure that there's also, some improvements and in some insertions, especially those that you think that they will also affect your responsibilities, and also especially in the local. I think you are talking about the local government. You don't have issues with the public sector as an institution, but also the local government. We have noted all those issues, and thank you very much to COSATU. And we are moving now to the Public Affairs Research Institution, and we have been told it's also physical here. Thank you very much, COSATU. No, thank you very much. We can proceed.
Good morning to honourable members, the chair, other presenters and organisations in the room. I present today on behalf of 4 organisations, the Public Affairs Research Institute, Corruption Watch, PSAM, Public Service Accountability Monitor, the Ethics Institute and Corruption Watch. I'm from PARI. At PARI I head the State Reform Programme by way of context for the nature of our comments on the bill. And that program is specifically focused on looking at questions of how to stabilize the political administrative interface, how to ensure that the public administration is more responsive to democratic mandate and less affected by patronage. So those are the kinds of context in which these comments on the bill today are made. So quite different focus, for example, to COSATU. Tomorrow we confine our comments primarily to Section 8 of the bill, and tomorrow we will make more extensive comments on the Public Service Act amendments. So we welcome the bill, and we especially welcome its intentions to clarify important definitions in Section 8, which deals with prohibitions against public employees conducting business with the state. Before we provide those specific comments on Section 8, just a note on the question of a single public service. The original intention of PALMA was in part to create or to enable a single public service or single public administration. And in the memo to the bill that was issued with the call for comments, this vision, it was noted that this vision wasn't fully realized in PALMA when it was enacted. And in a sense, the ambitions of the Act have been scaled back. Our sense is that this concept of a single public service is incredibly important for addressing the developmental effectiveness of the public administration, but it's a potentially quite contentious issue. It can be interpreted in multiple ways, so we strongly suggest that there is a national conversation on this theme so that we can sort of unpick it, pull it apart, and look at exactly what we mean by that term. The concept of a white paper and a green paper is not one that we use that often anymore. But I think that, the development of a white paper may have been very productive in the case of this concept of a single public service, and maybe it's not too late for a return to that kind of policy statement and debate on the theme. Okay, so our comments are now more specific to amendments in the bill. As I said, we confine ourselves mainly to Section 8. We welcome the clarification that the bill provides on important terms used in that section, although we suggest that it can be strengthened to provide better safeguards for the public administration from corruption. Our sense is that Section 8 does not adequately address a situation where employees might not be directors of a company, but are nonetheless the ultimate beneficiaries of such contracts. My own PhD on the education sector came across quite a few examples of this when companies were registered under the name of one person, but benefiting other people illegally. To close such a gap, we suggest that information regarding beneficial ownership of companies, or rather that the bill states that beneficial owners of companies can also not do business with the state. And so that that is made clear, and that it's quite clear that failure to comply with that provision constitutes a criminal offence, an act of misconduct. We also propose that Section 8 is made applicable to employees of public entities. There are a couple of other places in which we think that the bill should extend provisions also to public entities. Another proposal is that Section 8 is finalised with reference to the Public Procurement Bill. As we all know, the Public Procurement Bill is currently also sitting before Parliament, and public hearings on the bill were held, I think, about a month ago or so. Clause 13 of the current Public Procurement Bill automatically excludes persons related to public office bearers, including spouses, related to party leaders, public servants, municipal employees, etc., from making bids in procurement in the institution in which that relative serves. We feel that it's important that such a provision is enacted either through the finalisation of that bill or through some other legislative amendment. So in other words, it's about watching what comes through that parliamentary process on that bill and ensuring that it closes the gap, either through that bill or amendments to this one, because it's not entirely sure whether the bill in its current form will be passed. We're also concerned that Section 8, subsection 4, which is a new clause in the Act, could be abused. It currently reads, the Minister may prescribe that certain transactions between an employee and an organ of state, which are remunerative but not for profit, do not constitute conducting business with an organ of state. We suggest that the Act indicate under what circumstances this clause would be applied, in what form the Minister will prescribe this, and we suggest that is done so in regulations, and we ensure this is open to public scrutiny. I think one of the other presenters made a similar suggestion. Our fifth comment, also again on Section 8, is that the Act creates an obligation for government to develop and manage a comprehensive database of all public administration employees. So either a digital solution that is a comprehensive database or some other kind of plugin which enables you to search relevant databases so that employees can be checked against important information relevant to integrity, including on company directorships, beneficial ownership lists, declarations of interest data, and so on. So a comprehensive database that would support the ongoing work of the DPSA, for example, in setting up this new unit. I can't remember, it's got a very long name, this sort of integrity unit that's been set up, I think, headed by Solomon Vermaak. Finally, on Section 8, we strongly support the inclusion of another new clause, Section 8A, which deals with the cooling off period for public sector employees, strongly supported. And then a very final note, Section 9, disclosures of financial interests. Read the disclosure, which is now amended to clarify that this includes public service employees and those in municipalities. We also propose it's extended to public entities. That's it. Thank you very much.
Very much to Parry. Honorable members, that's the end of the presentation, and issues to be presented to this committee for attention. And I will then request members who wants to say something to this presentation. Honorable Ntuli.
Thank you, Chair, and we would love to thank Parry in this regard, and also welcome their presentation. And it's quite a crucial submission touching various issues of the bill. And indeed, the committee, the portfolio committee, they are indeed leveling the fields for the portfolio committee for the debate in future. Once again, thank you very much for the submission and for taking part, and also realizing that the work that we are doing there is not hidden. The public is behind us. Thank you. Thank you very much.
No, thank you very much, Honorable Ntuli, and thank you to yourselves, Parry. We've picked up some few issues, and especially on Section 8, how to that section be strengthened. And obviously, you have said you also want to understand how is the minister going to monitor it. But however, in all the other sections, you welcome them, you support them. I think that's what I've picked up from your presentation. But except the Section 8, that then will be clarified also by the department in the next process after this one. Thank you very much, ma'am. Thank you. Honorable members, I know that the next presentation was supposed to be the Western Cape government, and I've been told that they will be available at 1 o'clock. If the Auditor General of South Africa or any presenter is available, because I know that after the Western Cape government is the Auditor General of South Africa. We will then take them if they are here. I must just check who are the presenters available. Good morning, ma'am.
My name and South Africa, in terms of providing us our comments on the intended amendments to the Public Administration Management Act. Chairperson, we would like to thank the committee for allowing us to come and submit the AGSA's comments on this bill.
Just hold on, ma'am. Can you hear? You can't. You can't hear. Just hold on, ma'am. Can we just sort our IT? Honorable members can't hear you. Just hold on
Thank you,
for
ma'am. I'll also try this.
2 minutes. Can we, honorable members, because we're still dealing with managing IT, have a short break of 3 minutes, then we'll come back.
Yeah. I mean, it's going. It is there. I'm muting the return so that I don't get this coming back at me, but that's fine. Because you're getting the feedback from the output, and that we know is perfect. But now what we want to do is we need to get that audio into here. So it comes directly from me. So the person who runs the AV here needs to come and do it. Okay. Because they know where everything is. So let me show you what we did. I was in this morning. How are you? So you're not probably you can't replace the candidate after the deadline. So he waits for the deadline. He does something, whatever you think he does, to persuade them. So that's why we were able to. Even one, because we weren't there. That even doesn't matter. All that's been shown here has been presentation. Not through, but that means where's our table that's coming into this room. In terms of what we should be sending. Well, we send it during that. So I've plugged into this by SDI. Yeah. But we're seeing this. Now we're seeing this. But you see, we're also wise. We're also wise. We'll get there.
I'll check the first time. I think the reality is Yeah. You must have to.
Honorable members, can we proceed? And I will hand over to the Auditor General South Africa, Ms. Grootboom.
Good morning again, Chair. Am I audible now?
That's much better, Ms. Grootboom. You can proceed. Thank you.
Thank you so much, Chair. Good morning to all the honourable members. The Auditor General South Africa wishes to express its gratitude to the committee for allowing it to come and submit its oral commentary on the amendments to the Public Administration Management Act. In terms of our mandate, ma'am, the AGSA, as the supreme audit institution of South Africa, is mandated to provide assurance that public funds are spent in a transparent and accountable manner. So it is for this reason, Chair, that the AG is very keen on these amendments to the Public Administration Management Act, because it is our belief that these amendments will ultimately contribute, one, to the professionalization of the public administration, and two, to the fight against corruption, which in turn will shift public sector culture towards full accountability for ethical, financial, and performance management. Chairperson, in terms of our comments, we will start with clause 2, where it seeks to substitute section 5, provide for the transfer of suitably qualified employees subject to those employees' consent being obtained between the public service and municipalities, and also between municipalities themselves. And also then it protects the continued employment, the tenure of these employees that will be so transferred, and they will not suffer any reduction in remuneration or their conditions of service. Now, the AGSA has over the years emphasized the importance of appointing capable officials in the public service, municipalities, and public entities. And therefore, the AGSA supports this clause, and it provides a mechanism to transfer employees who are capable between the three spheres of government and between municipalities. It's further submitted that the mobility of capable employees who know what they are doing and are fully equipped to perform their jobs will address skill shortages, experience in the public administration, ensuring that these institutions will be able to deliver on their mandates, and in so doing improve service delivery and the lived realities of our people. Chairperson, that is in terms of clause 2, that we have that. Then in terms of clause 5, conducting business with organs of state, the AG supports that clarification that is submitted. Also, the fact that the application of this section extends to public entities and institutions performing functions in terms of the Constitution or provincial constitution. So that expansion of the scope of the Act then is welcomed. Further, that clarity that was provided in terms of ex officio directors is also welcome, so that it eliminates the unintended consequences of employees then being held, finding themselves guilty of contravening Section 8 because the entities that they work for does business with organs of state. Chairperson, with regards to the conduct of employees, clause 6, conduct of employees or former employees participating in the award of work, this amendment is welcome, Chairperson, because it will certainly assist in curbing corruption, Chairperson. So the AGSA supports that. This new provision providing for post-employment restrictions. And Chairperson, in this regard, when we look at the term, the 12-month period, it is the Auditor General's submission that this 12-month period, particularly where we look at contracts that are over 100 million or more, that consideration should be given to extend that restraint of trade period to a longer period, whether 18 months or 24 months. Because as I think the gentleman from COSATU also stated that employees senior managers can actually ensure that contracts are awarded and they throw the javelin and then join that company that they threw the javelin to in 13 months' time, and yet they would not be found wanting. So our submission is that consideration should be given to extending this period to certain thresholds of the amounts of contracts that the public administration institutions will enter into. That is with regards to that, Chairperson, to curb corruption. With regards to compulsory education and training, and the establishing the National School of Government as a department, the Auditor General is obviously in support of that, because we know that to build a capable state, a crucial leg thereof is to ensure that we have employees in these institutions that are suitably qualified, knowing what they do, and in so doing, then deliver on the mandate of those institutions. So, Chairperson, in summary, then the Auditor General supports these amendments, save for that consideration in terms of limitation and restraint of trade. So all of these amendments are then supported, Chairperson, because it is our belief that it will improve service delivery, and in turn, that will then have an impact on the lived realities of our people on the ground. Thank you, Chairperson, for affording us the time to present our comments to the committee. Thank you.
Thank you very much. Auditor General, South Africa. Yo. Thank you very much, Ms. Grootboom, from the Office of the Auditor General. And in your presentation, you have said you welcome all the provisions to this bill. And I will give them to honorable members if they want to say something. Honorable members? Okay, I can see the hand of Honorable Ntuli.
Thank you, Chair, and we'd like to welcome the presentation or submission from the AG, and indeed it is in support of the work that this committee is striving for, and hoping that when the time comes, the Portfolio Committee will deliberate on such issues that have been raised by AG. Thank you, Chair. Thank you so much.
No, thank you very much, Honorable Ntuli, and thank you to the Office of the Auditor General with their submissions, and further also, you know, welcoming all the provisions of this bill, and we thank you very much. We are then, honorable members, moving to the next presentation. If Tshwane municipality is here. Tshwane. They're not here. Oh, they're not responding. Is Mr. Avin Bola in the platform?
Yes. Good morning, ma'am.
Mr. Avin.
Yes, good morning, ma'am. My name is Richard Wilkinson. I'm the legal advisor to the Executive Mayor of the City of Tshwane.
Tshwane, okay. Okay, honorable members, the next presentation is from Tshwane municipality. Thank you. Thank you.
Hi, good morning, ma'am. My name is Richard Wilkinson. I'm not sure if you can hear me. The connection seems to be very bad.
Honorable members. Yes, we can hear you. Thank you. Thank you.
May I proceed? Sorry, I couldn't hear what you said. Okay, I may proceed. All right. Good morning, ma'am. My name is Richard Wilkinson. I'm the legal advisor to the Executive Mayor of the City of Tshwane, Mr. Celia Brink. We'd like to thank you very much for the invitation to present to the committee today. I would like to just indicate that our presentation will be substantially the same as the written submission which we submitted on the 28th of July 2023. And so if I may briefly take you through that submission. The explanatory memorandum which accompanies the bill provides as follows, that the purpose of the bill is to give effect to the vision of the single public administration. Main objects of the bill are to improve service delivery through the alignment of human resource, governance and related arrangements in the three spheres of government, to provide further provide for the transfer and secondment of employees. The Executive Mayor of the City of Tshwane would like to state clearly and unequivocally that the City of Tshwane is resolutely opposed to the notion of a single public administration, and it is on this basis that we register our strong opposition to the bill. We believe that the introduction of this concept will be prejudicial to the autonomy of the local sphere of government, and furthermore, that the bill is likely unconstitutional. That is the essence of our submission today. With your permission, Chairperson, I would like to briefly cover in greater detail what our constitutional objections to the bill are, as well as some of our policy objections to the bill. Chairperson, with respect, we believe that there are at least two grounds which support the assertion that the creation of a single public administration is unconstitutional. Firstly, the bill undermines the autonomy of the local sphere of government. Section 156, subsection 1 and subsection 2 of the Constitution provide as follows. A municipality has executive authority in respect of and has the right to administer the local government matters listed in Part B of Schedule 4 and Part B of Schedule 5, and any other matter assigned to it by national or provincial legislation. Subsection 2 says, a municipality may make and administer bylaws for the effective administration of the matters which it has the right to administer. Furthermore, and this is crucial, Section 153 of the Constitution states that a municipality must structure and manage its administration and budgeting and planning processes to give priority to the basic needs of the community and to promote the social and economic development of the community. Chairperson, if I may just reiterate that line, because I believe it is absolutely crucial and it is central to our submission. Section 153 of the Constitution states that a municipality must structure and manage its administration. And we believe that any national legislation, such as the proposed bill, must be in conformity and must reiterate Section 153 of the Constitution. Chairperson, we believe that the above provisions are instructive and that each municipality is fully empowered to administer its own affairs, and that the staffing of the administration of the municipality is a matter that falls squarely within this ambit. Secondly, it is important to recognize the distinction that exists between the public administration and the public service. Section 197 of the Constitution provides as follows. Within public administration, there is a public service for the Republic, which must function and be structured in terms of national legislation. Accordingly, it is clear that the public service is a subset of the public administration, and that whilst the ambit of the public services encompasses national and provincial spheres of government, it does not extend to the local sphere of government. Whilst local government is undoubtedly a constituent part of the public administration, the employees and administrators of local government are most certainly not part of the public service. The bill disregards this distinction, and in so doing, it is not compatible with the architecture set out in the Constitution. And so just to reiterate that point, the public administration, if I may just put my hands there so you can see on the camera, the public administration is this broad, and inside the public administration there is a subset called the public service, and that comprises national and provincial spheres of government. However, outside of the public service is a separate component which includes local government, and we don't believe that the bill respects that distinction and is effectively trying to incorporate the local sphere into the public service in a way that is not contemplated or endorsed by the Constitution. Chairperson, with your permission, I'd like to just raise some of the policy objections that the Executive Mayor of Tshwane wishes to submit in respect of the bill. Besides the constitutional points raised above, we must express our strong opposition to this bill on policy grounds. The local sphere of government in South Africa is in deep crisis. By far the most debilitating policy has been the decision to implement the practice of cadre deployment across all spheres of government and organs of state. This has been exhaustively documented at the Zondo Commission, also known, or at the State Capture Commission, which has been referred to as the Zondo Commission. Unsurprisingly, the South African electorate has begun to change its voting behavior, and it is in light of this that the multi-party coalition government, which the Executive Mayor leads, was elected to office in the city of Tshwane. The political mandate which the multi-party government has been given is absolutely clear. Its role is to reverse the impact of cadre deployment and to rebuild state capacity. The proposed bill presents a clear and unacceptable threat to the city of Tshwane's mission to reverse cadre deployment. The proposed bill seeks to place enormous power in the hands of the national government to transfer, or effectively to redeploy, employees around the country and across spheres of government and organs of state. Accordingly, any attempt by a municipality such as the city of Tshwane to root out incompetence and corruption, or to build state capacity, can easily be undermined by the national sphere of government. This is unacceptable to the city of Tshwane and will be resisted in every possible forum, including using legal and constitutional means. Therefore, Chairperson, I have been mandated to make very clear today that any attempt to centralize the organization of the public service and broader public administration under the auspices of the national sphere of government will undermine the authority of local government in a way that cannot be reconciled with the prescripts of the Constitution. Furthermore, the creation of a single public administration will make it impossible for local governments to develop distinct ways of governing that are responsive to the political preferences of their respective electorates. And an additional point we should make here is that South Africa has over 250 separate municipalities, and those municipalities reflect a wide range of geographies and demographics and economic circumstances. And therefore it makes sense, it makes logical sense for each municipality to be tasked with determining how to staff its administration. Therefore, the Executive Mayor of the City of Tshwane wishes to express his opposition to the bill in the strongest possible terms. We do not believe that minor adjustments will remedy the defects in the bill, the essential premise of which is fundamentally flawed. The enactment and implementation of the bill will inevitably give rise to litigation. The Executive Mayor is highly confident that this litigation will result in the bill being declared unconstitutional by the Constitutional Court. Nevertheless, such a legal process will inevitably cause delay, confusion, and significant expenses for numerous parties. Accordingly, the Executive Mayor urges the Minister for the Public Service and Administration to withdraw the bill in its entirety. And with your permission, Chairperson, those are our submissions for this morning, and I am available to take any questions that you may have in that regard.
Thank you very much to Tshwane Municipality with your presentation. I will then take hands for clarities or comments from honorable members. I only see one hand of Honorable Ntuli. Over to you.
Thank you, Chairperson. Chair, one would love to welcome the submission from Tshwane Municipality, and also thanking them for taking interest to the work that is being done by this Parliament and this portfolio committee. And indeed, believing on the freedom of speech, that all citizens of this country have got a right to participate to whatever legislation that is being brought about by this government and this Parliament. And Chair, one is not going to ask any question or any clarity seeking question. It was just a comment of thanking Tshwane Municipality for coming forward with this submission that will also create the platform for this portfolio committee when the processes are unfolding for a debate. Understanding that these two bills before Parliament and before this portfolio committee is for the future of this country and the people of South Africa, and it's for them to interact in these bills. Thank you, Chair. Thank you so much.
Thank you to you, Honorable Ntuli, Honorable Striper.
Thank you very much, Chair. Just to make the observation that I've been quite struck already by this theme that's emerging across all of the submissions we've seen regarding encroachment into the local government sphere. I think it's important for us, even as we anticipate the further presentations, to make this observation that it's been striking stakeholders coming from across the spectrum and with different perspectives have really now flagged this thing quite strongly with the committee. So I just wanted to note that's clearly a theme that's coming through. Discomfort with the extent to which this amendment would encroach into the local government sphere. Thank you, Chair.
Thank you very much, Honorable Schreiber, and thank you to the Tshwane Municipality. We have noted all your concerns, and in fact, I've picked up that you are saying you are opposing to this bill, and it's noted by the Portfolio Committee. Thank you very much, Mr. Wilson. The next presentation will be Mr. Alvin Pula, if I'm pronouncing the surname correct. Is Mr. Alvin in the platform? Okay, now that Mr. Avin is not in the platform yet, can we then move to Ms. Nomfundo Tofu?
Good morning, Chair. This is Nomfundo Tofu. I hope you can hear me.
Yeah. You are loud. Thank you very much.
Thank you so much, Ma. I had submitted inputs pertaining to the amendment on the 3rd of July to the secretary of the committee. And my presentation will speak exactly to those inputs that I made on the 3rd of July. The first input speaks to the individual transfers of employees in between the different spheres of government. And this is how it reads, the first input. The matter pertaining to individual transfers, there is an addition which clarifies that employees can be transferred between a national, provincial department and a municipality. However, my concern is that there is no system in place to ensure that there is effective transfer between these entities, such that which is according to the clause 530A, which is suggested that the transfer does not interrupt the employee's continuity of employment, as well as the other related benefit. My suggestion then is that DPSA must ensure first that these systems in the national department, provincial departments, and municipalities are integrated to ensure continuity, because currently as it stands, if an employee transfers from a national, provincial department or a provincial department to a local sphere or vice versa, the service is interrupted or kind of discontinued. I'm saying this, I forgot my apologies, I forgot to introduce myself. I'm Nomfundo Dofu, I'm currently an employee of the Department of Public Works. However, my inputs are individual, and they do not reflect what the department is saying. This is just me. I'm saying this because this tends to affect most of public service employees when they move in between these spheres. This affects the pensions as well as the continuity of service. I'm making an example. I started working for the public service in 2003. And now I'm in 2023, so that means I've been working for the public service for 20 years. Should I make this move, which at sometimes becomes fatal to other employees, it would affect me in an adverse manner. Let's take, for example, a case in point, a case of the employees in KZN at Umsunduzi municipality, where employees' pensions were affected when they had to exit the system. Let's say I move with my pension from GEPF and I move my pension to a particular pension house that the municipality is using. My pension gets affected adversely in a particular way because I also have to move pension houses. I do not have a problem with the clause, but I have a problem with the fact that it does not have a suspensive clause which stipulates a criteria that must clearly be followed in order for this particular objective to be met. It's a good intention. However, it must be stated in the legislation in order to protect employees. Secondly, my other concerns were around the conduct of employees or former employees participating in the award of to service providers, award of bids, award of work. I had a huge concern, which is contrary kind of to, I think, the other concerns that I think AG stated, and it's also different to what COSATU stated. There is a period that is suggested of 12 months, which an employee should not or may not accept a contract of employment with another entity which has received an award that particular employee played a part in. I personally feel that that clause is kind of too restrictive and should be given further consideration. The reason why I feel that it should be given further consideration is that I am not so sure if it doesn't contradict with some of the already existing rights in the Constitution and some of the labor legislations that exist in the country. Also, while still on the matter of the conduct of employees or the conduct of former employees who participate in the award of work to service providers. I had an issue with the proposed, I think it's clause section 8A, C2, with which contradicts with the currently existing section 9 of the Public Management Act 11 of 2014, which prescribes that if there's any gifts or gratification of sorts that are given by service providers, they must be declared. I have an issue there because then you would have a legislation that we would be putting in place, and there's another legislation on the other side that is saying something else. I also even went through the Municipal Systems Act of 2000, I think it's Schedule 2. There is an item or a clause that speaks to also the conduct of municipal employees or municipal staff, which dictates that it's neither here nor there whether you were involved in any award, or you were involved in evaluation, or you were involved in any process in supply management, in the supply chain management of goods and services. However, you just need to disclose your relationship or disclose whatever gifts or any kind of gratification that you've received from any or any relationship that you have with a supplier or a service provider. And also, whilst we on clause 8A, I think it's clause 8A form, I believe that that particular clause will create inequalities and some kind of inconsistency within the public service if we are to speak of this one public service, due to the fact that the particular clause gives the executive authority powers to approve a period shorter than the 12-month period that is contemplated in subsection 1 or 2. The definition of then the executive authority according to this amendment bill would be your accounting, would be your minister in that particular department. Let's say, for example, it's the Minister of Public Works, or it's the mayor of Raymond Mhlaba municipality. So it gives them an opportunity to alter the 12 months period to be shorter. And so it means then if we're this particular one, so-called one public service, then someone else can take employment with someone that they've given a contract to within 6 months, or they can take employment with someone that they've given a contract to within a period of 2 months. And other departments, maybe for lack of a better word, would be lazy to write policies, internal policies, and therefore that means that the actual act would apply, meaning that they cannot find employment with a particular service provider that they've given a contract to within a period of 12 months. So their period then would then be longer. So, and therefore it means that executive authorities would alter this particular clause to suit their own agendas or to suppress public servants. I would therefore prefer or recommend that these powers be given only to the minister, of which in this particular bill, the minister is defined as the Minister of DPSA. Whilst also on Section 8A, it's 8A1. I furthermore would like to recommend that powers to fix this threshold for the threshold for bid awards as stipulated in 8A1 should be prescribed by the minister so as to guide also against inconsistencies. AG came in and said the threshold should be 100 million. Someone else will come in and say the threshold should be 50 million. Someone will come in and say the threshold should be 1 billion. If then the minister is the one who fixes the threshold, then would then have an annual bulletin that prescribes that currently the threshold is 1 million, currently the threshold is 100 million, whichever suits the minister according to the research that they would have done. Thank you so much, Chair.
Thank you so much to yourself, Ms. Ntofu, with your presentation. And honorable members, if you want to comment or say something to the presentation. Thank you very much. There's no hand from honorable members. And Ms. Ntofu, I think we have noted all your issues or your concerns. Like all other presenters, we have noted one or two common issues from yourselves. And thank you very much. We will deliberate after this process, and also the department will respond to some of these issues. And obviously will then communicate to all the stakeholders. And thank you very much for your time and your presentation. And now we are moving to the next presentation, Mercy.
Honorable Chair. Excuse me,
Yes,
Honorable
ma'am.
Chair.
Yes, Mr. Ufu.
It's Grootboom here from AGSA. I just want to clarify what the previous speaker said, Chair. It's not necessarily that we say 100,000 should be the threshold. All that we are saying is that that 12-month period should be considered, so there should be different thresholds being considered, such as 100 million. So whether the contract is for 500,000 or a million, but when it comes to big infrastructure projects like 100 million, then consideration should be given to extending that time frame. So I just wanted to clarify that, Chairperson. Thank you.
No, thank you. Thank you, ma'am. Honorable members, I think you have also noted the last point of just after the presentation of Ms. Tofu, the comment from the Auditor General, and we are moving to Mr. Avin. We're not sure if he's in the platform, because we are left with Mr. Elvin and also the Western Cape government that must present here. Is Mr. Avin in the platform? Honorable members and colleagues in the platform will take an early lunch and come back at what time, Mas? Thank you very much, colleagues, and we are adjourning now until 1 o'clock. We're coming back at 1 o'clock so that we take the two presentation of the Western Cape government and Mr. Avin Bula. Thank you very much. We're adjourning now until 1 o'clock.